speaking as a failed lawyer, I would say that whenever a layman tries to interpret constitutional law and reads the Constitution, which is very short, the Constitution is extremely brief as far as legal documents go. Uh, if you don't read it in the context of the time and place in which it was written, if you don't know what the terms mean, if you don't know how the terms have been being used by the surrounding document, if you haven't read the Federalist Papers, if you haven't read the Declaration of Independence, both papers, which are, by the way, do not have controlling legal authority. Okay, then you're not going to get the correct interpretation. You see, that's the way interpretation works. And if you're a member of an organization, let's say like the Supreme Court or the Catholic Church, that makes interpretations throughout the generations, one building off another, and can cite your precedent each time, then you understand the difference between a natural development and what we lawyers call activist judges who just make up stuff out of their own imaginations, and you can see the difference. Okay? You can see the difference.
I've noticed that when you talk to someone about St. Thomas Aquinas's 5 ways and his first argument for the existence of God based in, he says motion. And then they will make an argument about, they will make some refutation of his argument based in the idea that things move through space. And it's like, you don't understand St. Thomas well enough to make, like, you don't know what you're talking about, and it's glaringly obvious you don't, because
motion means change.
Motion means change.
Right.
Yeah.
A tree growing from a seed is motion by the Aristotelian definition.
But a leaf that changes from green to brown, even if it doesn't move,
right,
it's motion. That's change. Right. But, and I mean, it's a simple giveaway that they just don't know what they're talking about.